Hello, franchise friends. It's Simon here from FranRec. Hope you are well. I'm going to take you back to a show we did with Harvey Tuck hosting and Natalia Schwartz from Excello Law and myself, where we talked about mediation, a really effective way for franchisors to resolve any disputes in the network. A really interesting discussion. Take a look. Happy to answer any questions. And of course, if you feel you've got an issue that could be resolved through mediation, please reach out and I will be delighted to support you. So enjoy the show. Take care. All the best. Bye bye.
My name is Natalia. I'm a franchise lawyer, and I have also completed mediation qualifications. So I have gone down that path myself.
But more recently, I guess it was just a bit of a trigger, really. I was, let's get the elephant out of the room. Do I think that there is a problem in franchising? Do I think that there is a dark cloud hanging over the sector? No, I don't. I'm a passionate believer in self-regulation. The system isn't broken. It doesn't need fixing. But it's like any relationship. There are times when, you have a falling out, a disagreement. And, I think it's better for franchising, the brand franchising and the relationships, that these are resolved in a proper way. And I took a really deep dive into mediation and how it works, and took a real interest in it, and took a couple of 2 weeks out of my life and retrained as a mediator.
Litigation is always an option, but as Simon said, it's to take a perspective and to take the approach of "I'll see you in court" is not very helpful and is not very useful. So what mediation does is allows the parties to resolve a situation in an alternative setting. I mean, it's called alternative dispute resolution. So it's there as an alternative, as an option to being in court. But personally, I think the greatest, perhaps, one of the greatest reasons why mediation is so amazing is because you have so many more options with mediation. The flexibility of figuring out what that solution might be, right? Because when you go to court, there is only one option. You either win or you lose. And that's it. It's an outcome. And essentially what you do is you get money. But money is not always everything in terms of resolving what the problem might be. And the truth is our courts are overloaded, and the truth is litigation is a very lengthy process. So when people think, right, I'm in the dispute, I'm going to sue you in court, that's not going to happen tomorrow. That's not going to happen next month or the month after. You're going to have to live with the process of litigation for months and months and months. And it often takes, it can take 12, 18 months, sometimes longer, to actually get that date in court.
You can stay anonymous, but let's put up your point, because I think it's an interesting one. And it's put, hi all, what an interesting topic. I have been at the receiving end of a franchisor versus franchisee battle. I wish I had a mediator at the time to help us through the horrendous journey that we had. I mean, it's when things don't go right, it's difficult. It doesn't matter what way you look at it, it's always going to be a tricky situation. We've used the expression "talk it out," and it's great to hear, even though you've been through something that is really difficult, that actually you're reflecting back on it and wish that you had a mediator or somebody to help you navigate that experience.
We kick it off with a joint meeting where both parties can get to a joint session where both parties can actually set out their stall and set out their case in front of each other. And then what we then do is we break off into individual private sessions. So we take each of the parties into, as mediator, we take each of the parties into a separate room where we can really flesh out and get some more background on the issues and find out a little bit more about them as well. So you're building up a rapport and a really good understanding of both parties' interests, if you like. And then through a process, and again, I'm abbreviating this significantly. Natalia will say it's not as easy as that, but no, and it isn't easy. But the skill of the mediator, as I said, is to listen. You know, we're not there to judge, we're not there to advise, we're not there to negotiate. We're there to listen, and we're there to make sure that the interests of both parties are really put out there. And we have a number of different individual private meetings where we advance the process. And then when we're at a process where we feel that, you know, agreement can be reached, then we reconvene into a joint meeting where the detail is fleshed out, an agreement is signed, and thank you very much, that's legally binding and everybody can move on and get on with their lives. But that's a very sort of a very broad. Have I missed anything? But I mean, the idea, as you can see, it's all about dialogue. It's all about talking to people. And the biggest frustration I know that individuals have when they go to court is they always come away feeling I didn't get a chance to say what I wanted to say. You know, I didn't get a chance to say what I wanted to say. But mediation is all about giving people the opportunity to have their say and to get an understanding of the interests and the other party's position as well.
And I just wanted to pick a point just really quickly on language. I think the trouble is, right, inevitably, once you are in a dispute situation, and when it goes to lawyers, let's be honest, it becomes, the language becomes very accusatory, right? You didn't do this, you didn't do that, it's your fault. The language is very, you know, it's very harsh. So when you go to court, that just continues. So the language of litigation is very, you know, it's very personal. It's very much about fault finding. It's very much about who didn't do, you know, what it is that they were supposed to do. Whereas mediation is all about taking that emotion out. And that's why we have such a high success rate, and that's why it works, because like you said, people just need to be heard, people need to let their, you know, their feelings out. So that, you know, mediation allows for that. But then, as I'm sure Simon will back me up on this, the role of mediator is to manage, you know, is to manage the parties. And we always remind people that this is about respect, and that yes, you know, it's about respect, it's about the language. And you know, a good mediator is one who can really, you know, really listen and really de-escalate, and you know, take the emotional part out of it as much as possible. And that's why it works, because you've got this third part, you know, third person, this independent person, you know, because mediator is not connected to either party. And if anyone, you know, if a potential mediator has that connection, then they would have to excuse themselves, they wouldn't be a mediator. So you've got this independent third party who is there to, you know, to diffuse that emotional aspect. And again, that's why it works.
Yeah, absolutely.
I don't expect you both to sort of have a number right at mind here, but you know, generally speaking, does mediation have a good success rate in terms of preventing litigation?
Yeah, I mean, the number that I've been given is 90%.
90%. Wow. Okay, that's amazing. I mean, that's incredible. I mean, if that's the case, then that's a very powerful statement to make.
Yeah.
So, wow.
Yeah.
A mediator who has an understanding of franchising, that is really useful.
Yeah.
Because, you know, you're not, and I suppose this leads really well to, you know, why doesn't a mediator need to be a lawyer? Well, because like you said, you're not there, you're not making the decisions. And that's where mediation, again, is really powerful. Who is making the decisions? The decisions are made by the parties. So, you know, the mediator is not a judge. The mediator is not going to, you know, say you're right, you're wrong. The mediator is there to facilitate the conversation. So it is the parties who are ultimately reaching a decision, an outcome. And that's why it's so powerful, because if you are involved in the process of coming to a decision, and if you are actively involved in making a decision, you are much more likely to stick with that decision and see it through. Yeah, absolutely. So it is binding in a sense of that once you reach a conclusion, um, once there is an agreement of the parties, that gets documented. So what is really important is to make sure that it gets documented. And this is usually where lawyers come in, right? To make sure that it's documented correctly, accurately, etc. So as with any so what you end up with is a contract, and as with any contract, it's a legally binding contract.
Okay.
So we're talking hundreds of pounds as opposed to hundreds of thousands of pounds.
That's exactly it. Yeah.
I'm not. I've never had to pay a legal bill for litigation, but I mean, maybe some people can share that on the chat or on Natalia, for example. But I know, what does 3 days in a high court cost you? I mean, it must be significant.
Absolutely. And I mean, the maths here is really simple, right? Litigation, each party has solicitors, barristers, there are court fees, right? So each party is incurring those costs. With mediation, once you agree a mediator, and mediators' costs are usually split. Like Simon said, they're split between the parties. So you're not having each party racking up their costs like this. You're having, the parties have their costs, and then it becomes a joint, a joint expense. So it's a no-brainer. And yes, usually there is sort of a fee, a fixed fee per day based on a number of hours, and then once it's exceeded, there is an hourly rate. And that works really well because I haven't been in too many mediations myself, but those that I have been, you do tend to go right up to the 11th hour of what is included. And that sort of going over, I mean, that acts as a bit of an incentive to get things done, because both parties then know, what, if we don't get this resolved, we're going to have to incur costs and we're coming back, or, we have to carry on. Costs, yes, a cost of going to court. It is not unusual for those costs to be in £250,000, half a million pounds. You are talking about thousands. You're talking about hundreds of thousands.
Yes, I mean that's amazing. I mean, Natalia, you spoke about this being used between franchisee and franchisee. I always thought it would be a franchisor and a franchisee that this is used for, but
I have been involved in mediations between franchisees because, again, it's about relationships. So if you have neighboring franchisees who maybe, have fallen out or not seeing eye to eye, mediation can be a really, really great way of bringing them to the table and, resolving that situation. And actually, I would say probably in that situation, it's most of the time would be probably the only the only option available, because obviously a franchisee versus franchisee, they don't have a contractual relationship, and this is where it can get really tricky, and franchisors can find themselves as a piggy in the middle, because franchisees will inevitably complain to the franchisor. So you as a franchisor can then be in a very uncomfortable position of being forced into that situation where, what do I do? And both the franchisees and you as a franchisor may not want to damage that relationship that you have. So where that is the case, then I would urge franchisors, please consider mediation, because that enables you to have, to bring people to the table and resolve that situation, whatever that might be, and allow them to reach a decision that they can both live with and work with. And I have seen that being used very, very successfully. And franchisees who sort of ended up almost being enemies then actually had a really good working relationship. And, I'm not necessarily saying they're like best friends, but they're definitely on much better terms, and are now working together. And again, franchisor, for you, it's a win-win, because you now have both franchisees, happy and doing better and working better together. So it's great.
or refuses to enter the process. This is really interesting. You know, from either party, actually, if one is keen for mediation and the other isn't, is that the end of the road for mediation, or is there a way to get beyond that? You know, do the courts insist on mediation?
Yeah, absolutely. So, and this is perhaps the sort of the downside of mediation, is that it relies on people being willing and participating, right? But it's not, it's not the end of the world, because actually the way our process, the way the process works in England and Wales, and obviously I can't speak for other jurisdictions, but certainly in England and Wales, it is part of our litigation process that actually the courts will ask. So when it comes to the parties submitting, their paperwork, one of the questions will be, what methods of alternative dispute resolution have you considered, and what have you attempted? And in most cases, the court will basically say, in very simple terms, you cannot come to court unless you have tried it. So the courts will very much push you towards alternative dispute resolution, and more often than not, that is mediation. And if a party unreasonably refuses to participate in mediation, then usually what that means is that there will be cost implications. So even if you are the winning party, the court will essentially punish you for having used the court's time, and not considered mediation or alternative dispute resolution. So yes, the courts can absolutely help with that, and they do that. So that's
we have started to come to the end of today's session. So I think it would be really interesting if both of you could sort of sum up based on our conversation. We'll go ladies first in this case, but, just give us your sort of closing thoughts about mediation, and then I'll turn that over to Simon as well.
Absolutely. Thank you. So I think from my perspective, mediation is an absolute no-brainer. It gives both parties more options than than litigation does. It is certainly a much quicker, cheaper, better way of resolving disputes and preserving the relationship, or finding a way out with both parties, with both parties suffering as little damage as possible. So,
as I said, I mean, it's my message is mediate, don't litigate, franchise friends. Franchising is such a special relationship, and it works. Mediation works so well with franchising. Remember what brought you together at the start, and preserve your brand integrity, preserve your sanity, and preserve your bank balance, and that's mediation.